Hello, I'm Dina Lurje, and I'm heading the Anti-Competitive Agreements Division at the Lithuanian Competition Authority. Today I have a great pleasure and honor to talk with Mr. Sarunas Keserauskus, who is the head of the Competition Authority in Lithuania. My pleasure is even bigger because apart from being a great colleague at the Competition Council, I have actually first met Sarunas as a rather inquisitive judge at the competition law moot court a long time ago, which was the day when I decided to go into competition law. I'm not sure how much was that the influence of Sarunas or the competition law itself, but that remains to be unanswered. So Sarunas, I have known you as my professor, as a colleague at a law firm, as a colleague at the Competition Council, and as a co-lecturer at the university. So given all that, I am really enjoying having the opportunity to listen to your story on what has the evolution of competition law in Lithuania been during the last 25 years. So your story obviously is part of the bigger story of Lithuania. So can you tell me, how do you see the evolution of competition law in Lithuania, given its historical background of the 25 years? Do you think Lithuania at that time was even ready for competition law, which we have for so long already?
Thank you, Dina. Thank you for your kind introduction. I must share a bit of a concern to start with before answering your questions. Because the whole project is called Oral History Project. And we're talking history now. And the worry that came to my head was, are we history already? But then again, it's fine. I remember as a child, since you mentioned the start of competition law in Lithuania, I remember as a child in the 80s, I lived in a country that was then occupied by the Soviet Union, and it was a centrally run economy, regulated prices, regulated quotas of production. And back in those days, people were still talking about what was called the crime of speculation. This term speculation is very far removed from the ordinary meaning of the word that we have now in English. And the criminals were speculators. These were essentially people who were reselling goods for profit. That was a crime in Soviet times. Fast forward less than 10 years, that became a norm. So that was a huge transformation for the country. And as it happens, quite often in these transformations, rules came first, and the mentality of people followed. Was Lithuania ready? Well, I don't know, probably not. But you're never ready. There is never a good time to do that. Ask anyone, is it a good time to start a family, to move next to your career? People are trying to maintain the status quo. It's a bit uncertain. It's a bit dangerous. You step into uncertainty. So that's what Lithuania did 20-something years ago. The challenge was, of course, that with the rules changing, with the economy changing, political system changing, people remain the same. People who worked for the plan committee in the Soviet Lithuania, people who worked for the price committee in the Soviet Lithuania, these two pillars of the central planning economy, they were used to establish production quotas, prices for how much things had to be sold. And then the same people, they changed from the price committee to the competition authority.
So basically the people who were enforcing the speculation crime.
Well, not exactly. The speculation crime was a crime, so that was these were criminal cases. But yes, the same people who thought of reselling products for profit as a crime, they had to protect competition. That was a huge change. And I think it's easy to criticize those people for the mistakes that they made. We all make mistakes, and we are in a good position right now that we don't have to make those mistakes. We can make our own mistakes. But we have to understand, of course, that back then they did the best what they could do, because they were educated in Soviet times. There were no alternatives. No one showed the way. This is how to do things. And they were learning as they were doing things. These were interesting times. Our history was very condensed. So many things happened in a relatively short period of time. One of the first childhood memories of political significance was the death of Leonid Brezhnev, then Soviet leader. Then several deaths followed of other leaders, and Mikhail Gorbachev came to power. And then perestroika, free markets, independence, and so on. So that was, events were coming thick and fast. And you had to, well, we had no luxury of having time to understand them, assess them properly. We just moved on.
And obviously there were people also from the US and other countries who already had their systems running, but so they came and tried to assist and maybe to educate and to try to choose what way is best for Lithuania. How was this transformation? How was this assistance? Did it go too fast maybe? And that's what you mean by saying there was really sometimes no time to adjust all the new rules to the realities of the history that was preceding it?
The early 90s was an interesting period of time for international antitrust, because when you look at the articles back then, there's lots of discussion on what would be the best antitrust system for these new countries, because it's not only Lithuania, it's the whole Central and Eastern Europe. And there were lots of Americans pushing the American system. Europeans in the beginning were not too much concerned. They came later. So yes, Lithuania had people coming from the US, and they were quite influential in designing the first law on competition that we had. Just a couple of examples. For example, back in the early 90s, Lithuanian competition rules were not applied to vertical restraints, unless there was a market power in an abuse of dominance form. Otherwise, verticals were not covered. When you think now, that looked quite advanced. But then we moved to the European system, of course. Then again, we had a safe harbor presumption for market power. Below 40% market share, firms were considered not to be dominant. That was a pretty strict rule. Now we have the other way around. Above 40%, we presume there is dominance. So there was some US influence. There was quite a big discussion internationally on what is best for these countries. And we tried to pick the best without really knowing what is the best. But then Europeans came with a big carrot that is becoming members of the European Union, back then the European Community, and we followed the carrot.
We followed the carrots. And given all this background of Lithuanian history and the transition that took place from really a planned economy where pretty much the government regulated prices into what we call the free markets now, how did you, being born in the planned economy yourself, how did you decide to go into antitrust field and into competition law and fight for the free markets the way you learned what they are later?
Well, there was no big decision of fighting for free markets. Markets were pretty free back then, more free probably than right now in many ways. I didn't find antitrust. I think antitrust found me, because the first time I heard the term competition law was probably in 1994 in the company law classes. Someone had a book on competition law. I had no clue what that was about, and that was it. Then 1 year later, I joined as an assistant a law firm, and my first assignment was in competition law. I had to assess whether a public agency was acting as an undertaking, and if so, whether it was abusing market power. Well, I read the best part of Professor Zawish's book in 2 or 3 months. And then I came up with the answer, and I thought, well, now I know more or less everything there is to know on competition law. And I became the best expert in the law firm. I'm not too shy, as you can see. But to be more serious, that just goes to show not the level of my expertise back then, but the level of competition law in Lithuania.
And you said that was 1994, right?
So that was 1995. That was 1995. That was my first case on competition law.
And the first competition law in Lithuania?
The first competition law was adopted in 1992.
Okay, so basically 3 years later, you, having read about what an undertaking is, felt to be the most knowledgeable at the time.
I was quite certain of things how they should be. That is true. And that went all the way up to 1998, when we had, I remember, two cases, two cases with international flavor. The first case was involved a Swedish investor into the Lithuanian market that was accused of predatory pricing. That was high-tech predatory pricing back then, because most of other cases were just discriminatory pricing, which was another form of price regulation, to be honest, because the agency, pressed by politicians, was still trying to make sense of the free markets and the prices and everything that was going on. So predatory pricing was high-tech. Next year, we had the Coca-Cola case. I think I can say now that that was the case that opened my eyes to the world. So first of all, I came in contact with international lawyers and especially economists, including the American ones. And I also realized that was serious stuff, because the company was really concerned. They invested a lot of money, a lot of energy, prepared submissions, not in several pages, in tens or close to 100 pages. That was unseen in our practice. Big names. I only later on came to realize that these were big names, like Robert Willick, an economist from the US. And then I realized, well, perhaps I don't know that much. There are people who know a bit more than me. And this is much more serious than I realized in the beginning.
But you stayed in the field.
I stayed in the field. The good times went on. And then the thing that happened was that I moved on. I practiced law. Then I went to do my master's in London at King's College. Then I did my PhD at King's College. And the more I studied, the more I practiced, the more I came to a conclusion that I know a bit about a very narrow field, not much. So I think when I finish my career, when that happens, probably I will come to realize that I know nothing.
I'm glad we're in the middle of your career, though. Talking about your PhD thesis that you mentioned, that you did at King's College, what you are assessing is are competition laws in small countries, are they supposed to be the same ones as in their larger counterparts? And are the small competition authorities able, and even should they do the same investigations and run the same types of cases? And now, as you are heading the authority in Lithuania, it is pretty obvious that a lot of priority is being placed on investigations with regard to assessment of the conduct of the state as a potential violator of competition. So my question is, why is that? And if you see on a broader perspective in Europe and in the world, we are really a minority doing those kinds of investigations. So my question, going back to your PhD thesis, is this because we're a small country, or do we go back to our history on that again?
So you touch upon two things, the smallness and what to do about the state. I'll start with the smallness. There is nothing wrong in being small. Things just happen. My thesis was that when you're small and you have limited resources, much more limited than in bigger countries, you have to be realistic about what you can and what you cannot enforce. So my thesis was you should enforce what is possible. Clear rules. So mostly cartels. That is not to say that you should not enforce abuse of dominance cases or mergers, but you have to be realistic. You should not take on something that you should not be able to carry. Because when you look back in the 90s, the first decade of enforcement in Lithuania, I have already mentioned that most of the cases were abuse of dominance cases in the form of discriminatory pricing, without any assessment of the effects that this pricing had on businesses or on consumers. In a way, that was easy, but it didn't make much sense. The enforcement was not terribly influential. So I think that you have to focus all your resources that you have on something that is really important. And some say that if there is one thing to enforce, is the prohibition against cartels. So that's your main priority. How does the state come into this picture if we're talking about cartels? Very easily. Because the state is in a unique position. And the position describes that it can most efficiently restrict competition by far more efficiently, effectively than enterprises. Because the state can issue laws, other regulations that restrict competition. And if the state does that, the first harm is that it restricts competition. Secondly, it sets a bad example. So these are two reasons that you have to fight the state restrictions of competition. Quite uniquely among other authorities in the world, we had this power from the very start of our existence, from the early 90s.
Which is amazing, given that it was a planned economy with the state playing an enormous role in the markets at that time, and it was the state legislator putting this power into the toolbox. How did that?
It was quite impressive, and I wonder if that would happen now, if we had to adopt a new law, would we have the same provisions? But back then, I think people were idealists and also looking into the future. They saw the state, in some sense, as a bad thing, state that controls everything. So there was this idea that we should put into law a provision that restricts states' ability to intervene into competitive process. And that's how it came into being. And then it just went on from one law to another. And it makes sense for the reasons that I said, because the state can restrict competition, it does restrict competition, and by doing so, it does harm to consumers and sets bad example to firms. Because if you say, look, you cannot engage into cartel behavior, or you cannot merge into monopoly, it's what example do you really show if you do it yourself as a state body? If you establish restrictions that prevent newcomers coming to the market, if you protect your local producers, and so on and so forth. We still have these things in Lithuania. we're talking about the history, but it's still a relatively short history, no more than 20-something years passed since we had a completely regulated economy.
That is true, but do you think this priority that the Lithuanian Competition Authority now has, really addressing a lot of its efforts towards the assessment of the conduct of the state, do you think it is about to change, and it is so effective now because it's only been 25 years since the regaining of independence? Or do you think this is a task that competition authorities should do regardless of their position in the scale of history?
I think that is something that is not terribly unique to Lithuania. I think these things come up everywhere in the world to a large or small extent, probably to a small extent in countries such as the US with long history of market economy and relatively smaller state participation in the markets. But I think this should stay as a provision in the law, prohibiting state from interfering into competition at the expense of companies and consumers. As to priorities of our authority, I don't see them changing in the near future. We just have too many of those infringements, and we should combine our enforcement with advocacy efforts in this field. Because some of those infringements are done not because people want to restrict competition, simply they don't know better. And we're trying to address that issue as well by advocacy. And we're increasing advocacy efforts. We have been increasing these efforts in the last couple of years.
I think that's especially the case because, again, as you've said, lots of those people who are working for the government in Lithuania they've also been raised during the planned economy. So for them, a lot of things that are considered to be restrictions of competition without any advocacy done by the authority are still considered to be a norm. So I think
that is true.
There should be a dialogue on that, right?
But these things as competition, free markets, and so on, they did not come naturally for many people in Lithuania. Unlike in this country, in the US, for example. We learned those things. A good part of the population just learned those things. But before learning those things, they learned something else as well. And there is a conflict always in your head. And I think we'll need a change in generations as well. Which is not to say that what happened 10 or 20 years ago, what is going on now is something wrong. We're just necessarily passing through this stage. We're learning and trying to do better. But some reflexes from the olden days remain. You can see that, for example, when dairy prices go up, there are initiatives from politicians to regulate them, or to protect local producers, local farmers, to impose margins on supermarkets, to protect local manufacturers, and to give them priority in buying some materials like timber. Lots of these things, they come from different sides of political spectrum. And there is one explanation of that. People, they enjoy benefits of competition, but the trust in competition is still not that deep. So when things go wrong, the first idea that comes to your head, well, maybe I should intervene and regulate, as opposed to see how I could improve competition, and then explain to the people that they should wait for the benefits of competition to arrive long term. So there is this pressure of short-term benefits against long-term benefits, and for politicians, it's very difficult.
Talking of politicians, do you remember that when the law of 1999 was being put for adoption at the parliament, The only thing that was debated at the parliament was the question of whether the competition authority should be independent, which seems like the questions about whether cartels are wrong, whether abuse of dominance is a problem, was not an issue for the parliamentarians at the time. Do you think the question of independence of authority is still relevant now, or have people already come into terms with the fact that competition authorities should be independent?
You started by asking if I remember. I'm afraid I do remember. That's my worry about being part of history. But on a more serious note, yes, independence, the fight over independence of the competition authority back in the late 90s was the single biggest fight in the parliament when discussing the new law. There were some other pretty big changes in the law. For example, the prohibition of competition of vertical agreements that restrict competition and so on. But these substantive norms, the substantive rules, they received little or next to no attention from politicians. The single biggest issue was, would the competition authority be accountable to the government, to the parliament, or to the president? And I remember the prime minister saying that if you take over the competition authority from us, then we'll not be able to do anything about prices for dairy products. So that was the big argument. It just somehow happened that in the fight between these three camps, the government, parliament, and the president, the competition authority came out legally independent, which was a good thing. And we still have this independence, and we are very protective of this independence. The acceptance of the competition authority as an independent authority has not come easy. I think it's still a process in the making. From time to time we hear the criticism that is not based on some substantive arguments, but again, politicians mostly saying that, well, the authority is doing something wrong, they should do this or that. One interesting case that comes to my head to illustrate the matter is our last year's infringement decision in the Gazprom case. For most in the US, I think Gazprom case rings other bells. They know the Gazprom investigation conducted by the European Commission that is still ongoing. But last year we issued an infringement decision against Gazprom. We found Gazprom in breach of merger commitments given 10 years ago when we cleared the merger in Lithuania subject to certain conditions. So that was the Gazprom case. When we started the investigation, the government initially was very supportive. Then the government changed. The new government arrived, and they expressed some concerns. What were we doing? Because at that time, the government was negotiating with Gazprom a new deal on supply of gas. So I think there was some thinking that we could interfere into negotiations. Then again, the position switched. The government was publicly supporting our investigation. What we had to do in this situation, just keep on working. Don't listen to what people are saying, whether they support you or they don't support you. The case was risky enough, risk of becoming too political. So we didn't want it to get it out of control. And I think we were pretty successful, and we protected our independence. And that is a demonstration of why independence matters. But it also matters, and that is coming back to your question on the state's role in the markets. It also matters when we have to enforce the competition law against the state, against ministries and municipalities. If we were not independent, we would be quickly shut down. And I think that instrument, that tool, is only and can only be effective if we remain independent.
That is true. But now going back to what you mentioned on Gazprom and on the necessity to just keep working regardless of the political pressure around. Honestly, you know more than anyone else, seeing the competition authority both from the outside and from the inside, that conducting investigations is not an automated process as such, and there is a lot of human element in it. And the human element coming both from the background, the education, the motivation of the people that work for the competition authority. So how would you describe, have there been any changes in the human element of the authority during those 25 years, and where are they bringing us now?
I'm glad you mentioned that. I think the human factor is the most important factor in enforcement of any rules, and that includes antitrust rules. Regardless how perfect those rules may be, if you don't have good people to enforce them, you're lost. So we had quite dramatic changes. I think we discussed that a bit already, talking about the first decade of enforcement, where the authority was mostly staffed with people from the former State Price Committee and State Plan Committee. These were just realities of those times. There was no alternative. And those people were learning as they went, and they changed their thinking. It took some time, but they changed their thinking much quicker than the rest of the society.
Which is true, because I think I still had the chance to meet the colleagues at the Competition Council who were telling me, who are now enforcing cartels, cartel enforcement, and believed in the true market, and did the investigation the way it is being done in the U.S. and EU and in other jurisdictions. But what they told me is that there was really a list of prices that they had to check whether the list corresponds to the prices actually charged, and if there was no correspondence, then the difference was multiplied by 3, and that was the amount of fine imposed. So basically, really, these are the people that had to really do a big switch in their mindset to.
Yeah, and they did that switch because that was a good example that you mentioned, because that was the enforcement. Dominant firms, they were all listed in a list, and they had to declare the prices of their products. And if the prices went up, that was essentially an abuse of a dominant position. As simple as that. We don't have this anymore, and people made quite a big switch, quite a big jump, and we have experienced generation changes in the authority as well. If in the 90s, most people, because of restrictions imposed by the Soviet state, most people had very little opportunities to talk to foreigners, just any foreigner, let alone an expert in competition law. So everything was very new. So when Americans were coming to Lithuania in the 90s, then Europeans and so on, that was very new. These people were strange. When we look at the staff that we have now, they are much better traveled. They have studied in foreign universities. They know their way around. They're much more used to competition, to free market thinking. And that helps a lot because you don't have to start from beginning. You don't have to fight certain preconceptions in your head. Yeah, it's a different kind of dynamic.
But now, 25 years into the existence of competition law in Lithuania, and given the change in the authority and the change in the mindset of the authority, Do you think there has already been a change in mindset in the society as such? Because you have also had the chance to work at the OFT in London, seeing the way the British public, the British society reacts to the enforcement of the OFT at the time. Can you compare those, and what is your sense?
Well, I haven't done a particular study on that, but the general feeling is that, well, the British population is much more used to competition. They have long tradition of a free market economy, of liberal democracy. But still, people are people, and they are more or less the same everywhere. When the prices of fuel go up, they're not happy. Be it Lithuania, be it US, be it the UK. And of course, they put pressure on politicians to do something about it. What is different, I would say, is the reaction of politicians. Again, politicians are necessarily, to a certain degree, populists because they have to be re-elected. But I think what I experienced in the UK, you would never see a politician putting pressure on the competition authority to do certain things to regulate prices. Politicians there know that price regulation is impossible. That is not something that the competition authority does. In Lithuania, we still have this from time to time coming up, that the expectation from our authority is that we would take control of prices, but we're not controlling prices for more than 15 years now. That is history. We had this in the beginning of the 90s, not anymore. So the acceptance of the new system has not arrived fully yet, but I think we're on the right track.
And when you say the right track, you've mentioned that the Lithuanian Competition Authority has done a lot of advocacy on promoting competition law and the benefits of competition and the free market as such. Do you think, again, going back to your thesis and to the history of Lithuania, do you think the way advocacy for competition done in Lithuania should be the same that the advocacy being done in more mature economies like the US or the UK?
Probably not. Certainly not. You have to use tools. You have to pick tools that are right for a certain environment, for a certain culture. So Lithuania, of course, is different compared to UK or the US. And so the advocacy that we do right now, we mostly target, as you well know, we mostly target the public administrative bodies. We try to educate and to help with compliance people who work in ministries and municipalities, because that's where the restrictions of competition start. We also do a lot of work and they help the trade associations. Seminars on what to do and what, importantly, not to do when you go to a trade association meeting. So I think that is a bit different, because we're talking a bit more about basic stuff compared to a bit more advanced economies. And I think sometimes we're even taking over the role of the private practitioners. I think most of this compliance education in the UK and the US is done by lawyers, by economic advisors. In Lithuania, some big companies have already started doing this, employing lawyers and having compliance schemes and so on, but it's still not a very common practice, and certainly not for small businesses. But we're happy to do that. We're happy to take over.
And also, I think what shows that the understanding of competition law as a law that really prohibits conduct that restricts competition and which is bad for consumers is the fact that we have indeed recently have a couple of leniency applications in Lithuania, which we haven't had for many years, even though the leniency program has been there. Do you think this is a sign of a better competition culture, or what else should be done, or what do you think we maybe have done right for this to happen, or maybe we have done wrong and there could have been many more cases up until now?
Well, let's not get too excited about these leniency things, because there may be other restrictions that are beyond our control. And I'm mostly talking about the thing that, 20-something years ago, still 30 years ago, when Lithuania was still under Soviet occupation, it was considered to be a very bad thing to rat on people, to tell that your neighbor did something wrong to the security services, to the KGB. And that stigma is still there. So, because leniency means that you go to the authority, you say, you admit that you did something wrong, but you also say that someone else was with me. So you're giving in someone else. Who? This someone else may be a friend of yours. Because remember, it's a very small society. We're talking about of a business society of probably several hundred people, not more. Because Lithuania is as a country of 3 million people. So I think there are some limits, almost natural limits, to how successful the leniency program can be in such a small country with such historic experience. But as society develops, as this really becomes an old history, as people's mentality changes, I think the program will become more successful. But so far, having 2 applications, leniency applications in 1 year, I think that is a great success. But we can't really tell whether that was because of our efforts. We hope so, certainly we hope so, or because people are just changing.
Fair enough. I thank you very much, Sarunas. I hope the efforts will continue. I hope you'll be part of them. And thank you very much.
Thanks a lot.